Hello learners, welcome in the classes of industrial law. We are in the last unit of this industrial law, which is the law related to industrial relation. In this, we will learn about the two acts, which are the Trade Union Act of 1926 and the Industrial Dispute Act of 1947. The Trade Union Act 1926, it is a law which governs the formation, registration and regulation of the trade unions. It provides a legal framework for workers to form unions and collectively bargain with the employers on issues related to the workers in the employment such as wages, working conditions and other employment rights. The Trade Union Act seeks to balance the right of workers and employers, ensuring that the trade unions operate within the law. So, the trade union is formed specifically to resolve by coming unity of a body of workers against the employers or the policy makers. The, the objectives of the act are to provide legal recognition and lay down the rights and duties of trade unions and their members. The Act also provides for the registration of trade unions and give them the status of legal entity. Trade Union Act encourages industrial peace. Key definitions which are defined in the Trade Union Act of 1926 are the term trade union. A trade union, the word has been specifically defined in the Trade Union Act. It says it is an association of workers formed primarily for the purpose of regulating relations between employees and employers. It can also work for conditions, improving conditions, working conditions, and securing benefits like wages, health, and safety of the workers. The term registered trade union has been defined in the Act, and it says the registered trade union under the Act who enjoys the legal rights and protection. How the trade unions are registered under the Trade Union Act? The trade union can be registered by the requirement which can be fulfilled if at least 7 members in case of trade union for workers and minimum 10 members for trade union for employers are gathered together for the purpose of regulating relations between employees and employers for the promotion of workers' welfare, and this registration can be formally applied through application for registration under the Trade Union Act to the registrar of the trade unions. The application, written application must be filled with the registrar with the details such as the unique union's name. The trade union's name should be unique, which should not be verbally or in written form be similar to another registered trade union. Their objectives should be detailed and the list of office bearers should be described in the application form for the registration of the trade unions. The trade union's rules and constitution must be regulated. Once it has been registered, it is a legally recognized body. When the trade union is registered, it uses the benefits of a legal person. The benefits of a legal person are a legal status. Registered trade union is a legal entity which can make agreements, which can represent workers, and can also take legal action on the behalf of its members. The most important objective of the registered trade union is the collective bargaining. The sole purpose of registering trade union is the collective bargaining. to negotiate with employers for the benefit of the workers, their working condition and the employment terms. Trade unions' work is also to protect from arbitrary dismissal. Employer can arbitrarily dismiss the employee sometimes, so the Trade Union Act uh, has a power from the protection of arbitrary dismissal in the participation of strike. There is a legal support for the registered trade unions in the case of dispute resolution. uh, the legal support trade union has to provide to the complaints against the employer for the violation of the workers' right. Powers and functions of trade unions. The powers and functions of the trade unions are to represent the grievance to the redressal forums, the labor tribunals, and before the government. It is a duty of a trade union to represent. Another duty is the negotiation. Trade unions are responsible for negotiating collective bargaining agreement with employers on behalf of workers. Another power that is vested in the trade union is the advocacy for workers' rights. Trade unions advocate for better working conditions, better wages, and benefits for workers. Trade unions organize strikes in protest against the employer or the policy makers in accordance with the labor laws. This is a function of the trade union. What are other responsibilities of the trade union? That are the registration and compliance, financial accountability, regular general meetings. Trade unions office bearers has to hold elections and the regular meetings. Trade unions also has to adhere themselves with the constitution, the rules, the memorandum which has been associated in the Trade Union Act. Then the financial provisions regarding the trade union. Trade union has a registered trade union has a right to raise the funds for the union. The trade union raises the funds for the benefits of its members. The membership fees, trade unions can uh, levy the membership fees to become the member of the union for the activities such as the legal aid, organizing strikes, and administrative functions. There should be an annual audit of the trade union, and the annual audit report must be submitted to the registrar for the verification. Another benefits of the trade union are the improved working conditions, better wages, social welfare. As the world is moving from the sovereign powers to the social welfare, the whole world, all the legislation are objected towards the social welfare of the well-being. So the trade union uh, may offer additional benefits such as health care, pension scheme, and life insurance to their members. This is one of the best provision which a good trade union can do for the welfare of those members. Legal protection. Trade unions have been provided with the legal protection in the disputes among the employer and employee, including the issues related to the termination, wages, and working conditions. So the trade union is a body of the working members in the establishment who came together for the purpose of negotiating, showing their impact on the employer. There are some challenges nowadays faced by the trade unions, as the trade union was one of the sole methods to resolve the dispute and to demand from the employer. Now, in the year 2024, we are facing many challenges in the trade unions, such as the fragmentation. There are multiple number of unions in the single industry or establishment, which represent the leading fraction or the less effective representation of the peoples. Because of the fragmentation, the power of the unity is divided. So these are the fragmentation of the leading members is one of the challenges faced by the trade unions. Weak leadership. Trade unions suffers the from the weak leadership, making it becomes difficult to negotiate with the employers or to address workers issues effectively when there is a lack of leadership among the trade union office bearers. Legal and political pressure. Trade unions face legal hurdles and political pressures. It may be because of the political willingness to achieve something. It may be because of the political willingness to achieve some post. It may be political affiliation. Trade unions should keep away uh, from those such topics which are not related to the workers' welfare. There is another aspect, that is the lack of awareness. Many workers uh, are unaware of their rights under the trade unions. They can actively participate in the trade union. They can form the trade union. They can become the member of the trade union. So to negotiate uh, from the employer. Now we are finally at the conclusion of the Trade Unions Act, which is a law relating to the industrial relations among the employer and the employee. Trade union is a foundational piece of labor legislation. It provides a platform. Trade union provides for a platform to organize and platform for workers to organize together and advocate for their rights. Trade unions help improve the collective bargaining. By the method of collective bargainings, trade unions improve the bargaining power of the employees, which leads to the better wages, better working conditions, better social security benefits. These are the powers of a collective bargaining vested in the trade unions. Though there are some challenges, there are benefits, but nowadays, because of the fragmentation in the leadership and the demands and the political sidelines, the trade unions is facing biggest challenges these days in the era of modernization. As it is said in Sanskrit, Sangha Sakti Kali Yuge, Ekta में ही शक्ति है, unity in power. So when the workers will be united, they will surely be benefited under the Trade Unions Act of the 1926. These are the laws related to the industrial relation. The another act which is related to the industrial relation is the Industrial Dispute Act of 1947. This act was legislated by the Constituent Assembly as India got its freedom in the year 1947. The Industrial Dispute Act provides a legal framework for the settlement of industrial disputes between employers and employees. This act also covers disputes related to wages, working conditions, termination of employment. This act also promotes industrial peace and orderly harmony. Objectives of the Industrial Dispute Act: to resolve industrial disputes between workers and employers. The main objective of the Industrial Dispute Act is to resolve the industrial dispute among the workers and the employers. One of the objective of the Industrial Dispute Act is to promote fair treatment of workers and industrial harmony, to provide for prevention of disputes by establishing mechanisms such as conciliation, adjudication, and arbitration. One of the good objective of the act is to ensure social justice and labor welfare. Some definitions which are important to know under the Industrial Dispute Act are the industrial dispute. What is industrial dispute? It has been defined in the act that dispute between employer and employees, or dispute between employer and employer, or dispute between the employees and employees which are the workmen's, uh, relating to the term of the employment, is called industrial dispute. What is industrial establishment? Industrial establishment are the establishment where, in the industry where there are more than 100 workers are employed. Who is workman? Workman is a person who is employed in the industry, whether he is skilled, unskilled, semi-skilled. He is working as a supervisor, managerial post, or at the clerical post, or having some special technical knowledge, is a workman under the Industrial Dispute Act. So the Industrial Dispute Act provided for many authorities from the section 3 to section 11. Uh, One of the authority which has been authorized to be formed is the Works Committee. Every establishment which has 100 or more than 100 workers need to establish a Works Committee. It is a committee formed between employees and the management. In this, the representative of the employee or the employee and the representative of the employers sit together for the smooth functioning of the industry. There are provisions relating to the conciliation in the Industrial Dispute Act, which says uh, conciliation officer, it is the responsibility of the state appropriate government to appoint a conciliation officer who will resolve the issues between the employer and the employee. There will be a board of conciliation. When the matter becomes uh, big, or the matter is of large persons, related to the more number of persons, then the dispute is referred to the board of conciliation. The board is formed by the government, which should have a chairperson and the minimum number of 2 members and the maximum number of 4 members under the section 5 of the Industrial Dispute Act. Industrial Dispute Act also provides for a labor court to be established by the appropriate court, which should be presided by an officer who should be who should have been a judge of the High Court, or a additional district judge, or a district judge for a period of 3 years, or who should have served as a civil judge for the period of 7 years, can be appointed as a presiding officer in the labor court. There should be a national tribunal formed for the whole of India, whose presiding officer will be the should be the judge of the High Court, or should be a judge of the High Court. Then in the Industrial Dispute Act, they have a special provision regarding the layoff and retrenchment. Layoff is a temporary denial of job, and the retrenchment is the permanent removal from the job. So as we discussed, the mechanism for disputes are the conciliation officer, board of the conciliation, arbitration, adjudication in the form of labor court, industrial tribunal, and there is a mechanism which has been uh, given a legislative strata, that is strike and lockout. Strike, and these are used as a weapon against the employer and the employee. Strike is a weapon used by employees against the employer. In the strike, the employees deny to do the work which has been authorized to them, for for which they are being paid in the industry. The strike can be done by the group of body or a group of workmen who demands something from the employer. In this, the strike can be of many types. Strikes such as general strike, symbolic strike, pen down strike, instrument down strike, go slow strike. These are the forms of a strike in which the authorized workman does not work with the member of the workmen. Lockout is a weapon used by the employers against the employee. In this, in the lockout, the employer threatens to lock down his industry, uh, so the employees will automatically be left from the job. So this is a weapon used. Lockout is a weapon used by employer against the employee. In this, the employer threatens the employee that he will close his factory and all the workers will lose their job. So the strike and lockout can be the legal. When the strike is legal when you give a prior 45-day of notice for the strike, and the lockout is legal when you give a prior information and notice to the authorities under this act. So under this act, the lockout has been safeguarded by the provisions in the act. There is a provision for the labor code. The labor code should be formed for a specific area and which should be presided by a judge who should have been a member of a high court or a additional district judge for a 3 year or the district judge for a 3 year. In the case of junior judge, he should have served in the judicial service for the post of 7 years. These are the essential qualifications to be a presiding officer in the labor court. There should be an industrial tribunal established for the whole of India. The chairperson will be the judge of the High Court. The another provision which describes about the lay of retrenchment and closure. The lay of retrenchment and closure are affected are affecting especially the workmen under the Industrial Dispute Act. Layoff. Layoff means a temporary suspension of a work, usually due to lack of work, usually due to lack of work, where employees are entitled to compensation. In the layoff, the employer suspends the work which he has to do. It may be because of the unavailability of the raw material, lack of the power. Another term is retrenchment. Retrenchment is just opposite to the layoff. In the retrenchment, there is a permanent termination of employee from the job, and this is due to the reason of economic difficulty or the business reorganization. Retrenchment. In the retrenchment, there is a permanent termination from the job. When the employee is permanently removed from the job in the form of retrenchment, the notice of the retrenchment is made compulsory to be given to the employee, and with the notice, the employee is eligible to uh, get a compensation which is the 15 days of the salary of the last average months. At the time of the retrenchment, it is a duty of an employer to pay the 15 days of the wages to the employee before retrenching him from the job. Then there is a term closure. Closure means a permanent closure of a business. It is somewhat similar and different to the layoff, retrenchment and closure. In the closure, there is a permanent closing of business or unit of a establishment. So this is a closure. In the Industrial Dispute Act, it has been made mandatory to file a report of a closure under the Industrial Dispute. So strike and lockout are the two weapons which employer and employee use against each other for the sake of uh, fulfilling their demands. So, the Industrial Dispute Act 1947 has a vast provisions uh, regarding the industrial relations among the workman and the employer. So this act, industrial dispute, is of the year 1947. After the year 1947, Industrial Dispute Act has been amended sometimes. In the year 2010, the terms retrenchment, layoff, compensation and definition of workman has been instituted in the Industrial Dispute Act. And in the year 2020, the government of India under the leadership of Prime Minister Narendra Modi has legislated the Industrial Relations Code of 2020. This is the future of the industrial relation, the Industrial Relations Code 2020. It is an important reform which consolidates Industrial Dispute Act, Trade Union Act and the Industrial Employment Standing Orders into a single code. It provides new regulations on strike and employment conditions and dispute resolutions. The impact of the Industrial Dispute Act is very broad. It promotes industrial peace. When the industrial harmony is maintained, the industry is raised, so the country's economic power is increasing. Impact of the act is in the field of protection of workers' rights. When the workers' rights are protected, they works for the company organization, which is automatically benefited to the country. In the Industrial Dispute Act, there are various conflict resolutions such as courts of inquiry, conciliation officer, board of conciliation, labor court, industrial tribunal. These are the resolutions made under the Industrial Dispute Act. So finally, we are at the end of this unit, industrial law. In the final unit, we have been learned the law related to industrial relations, which are the Trade Unions Act of 1926 and the Industrial Dispute Act of 1947. So, when the industries works in harmony, they pave the way for the development, and when there is a development in the harmony, and then the country is benefited in its economy, and the uh, citizens of the country are tend to get the welfare life. So it is important to maintain the industrial relation so the employer cannot exploit the employee and the employee can benefit the employment. So these are all the provisions related to the industrial law. Thank you for learning the industrial laws. Have a nice day.